Hello, everyone, and welcome to Uncivil Law. I hope you are having a good day for everyone who's out there. And I am here today with the Sargon of Akkad, Akilah Hughes issue, and we are going to be covering Akilah Hughes' motion in opposition for attorney's fees. And we're also going to cover, of course, Sargon's original motion for the attorney's fees. So for those of you who are less familiar with the case, I'll give you a very brief rundown of this. Carl Benjamin, Sargon of Akkad, produced a video that was a compilation of cuts of Akilah Hughes' videos without other commentary except for the title, which, as I recall, was SJW Levels of Awareness, or RIP SJW Levels of Awareness. And Akilah Hughes was upset about this and sued on copyright infringement. She lost. The judge said it was fair use. I'm inclined to agree. And now we're on the issue of attorney's fees because the copyright law allows for the awarding of attorney's fees. And so we're going to be covering that. So let's get started. We're going to cover the original motion from Sargon because I haven't actually covered that yet. And then we'll cover Akilah Hughes' response to that. And we will discuss as it goes. Very exciting. And I know I'm a little late to the party, but as many people know, I've been in the process of moving, and so my availability has been very thin recently, so a little late on this one, but anyways, here we go. So we're going to start with Sargon's motion, because I haven't covered that yet, and we'll analyze that, and then we'll give the response to it. So let's see how it goes. Okay. Defendant, Sargon of Akkad, respectfully submits this memorandum of law in support of his motion for attorney's fees and costs under 17 U.S.C. 505. As many people may know, or may not know for that matter, the United States is on what's called English rule, which means every side pays for their own costs, including attorney's costs. So that rule can, of course, be changed by statute. And there are some statutes which allow for the awarding of attorney's costs, and this is one of them. So normally everyone has to pay their own costs, but there's a statute that says in the case of copyright issues that you can award costs, and that's exactly what we're doing here. So the plaintiff, Sargon, is a YouTube celebrity. Defendant Sargon publicly singled out and mocked plaintiff to discredit her and her political positions. This is from the complaint. Right? These quote marks, singled out, discredit her. That sounds like commentary and critique, right? Right. The plaintiff took offense to that, so she sued Sargon on the Copyright Act. That's not really what the Copyright Act is for. The Copyright Act is not for fees. The lawsuit was transparently an attempt to muzzle an ideological opponent for his critical speech. Well, if not the lawsuit proper, all the things that she said around and following the lawsuit we're definitely very clear of that. I don't know that it's necessarily clear on the face of the pleadings. I wouldn't go that far, but I would definitely say, with respect to her many, many tweets and social media things, that her motive became much more apparent, which is also a good reason that you want to be careful at best about communicating about ongoing lawsuits for these reasons. Yes, her attorneys put it in more professional language to avoid these issues on the pleading. She decided to open her mouth. She's the client. She has the right to open her mouth, but that comes with problems, so that's where we are. Even before he appeared in the case, Sargon warned plaintiff that the fair use doctrine barred her claims. He did. He sent her an email. I think it's actually as an attachment to her response, which seems odd, but okay. He informed plaintiff by a letter that if she chose to proceed, defendant would prevail and would seek attorney's fees. Plaintiff counsels withdrew. New counsel appeared for plaintiff at the initial conference. There, the court asked counsel to explain why defendant's work is not quintessential fair use. The court observed the only question presented by the complaint is whether fair use defense can be decided on the motion to dismiss or whether it would have to wait until summary judgment. All right, so this is the point. Well, this is a point when a lawyer may wish to reassess their case. if the judge during a preliminary hearing, which is, preliminary before any evidence has happened, right? It's usually very, very early in the case, one of the initial status conferences. And sometimes it can be very informal, depending on the nature of it. Sometimes it's not much more than you being brought back into chambers and the two attorneys are talking to the judge for like 10 minutes. That can be the hearing. So it can be very informal depending on the context. Of course, it can be much more formal depending on the context as well. But if the judge is saying things like, the only question in my mind is whether I should dismiss this now or after the motion for summary judgment, you may want to reassess the strength of your case. Just a thought. Apparently undeterred by the court's assessment of her claim, the plaintiff then made her first and only settlement offer, demanding Sargon pay $46,000 to settle a meritless case. Yeah, again, the judge is telling you your case is meritless. He's saying, I'm going to rule against you. I just can't figure out if I want to do it now or later. I can't figure out if the law allows me to do it now, because this has been a bit of an open question, which has been resolved in some cases, but not all cases. It's happened both in trademark law and patent law. The question of, can you resolve affirmative defenses on a motion to dismiss? Because in a motion to dismiss, you take everything the plaintiff says as true, right? That's the whole point. Everything the plaintiff says is true. So an affirmative defense is a defense. So you're considering things the defendant is saying, which, the courts have been a little bit struggling with this. It's like, can we do that? Because in a motion to dismiss, all you're looking at is the plaintiff. And now suddenly you're looking at the defendant. It's like, wait a second. That's a little odd. So the courts have been struggling with this a little bit, and justly so. It's not a trivial question. You're going from looking at the prima facie case of the plaintiff's case in isolation, and now suddenly you're considering things the defendant is saying. Right? This is not something we're used to doing in law. And the courts are very, very lower C conservative. They don't like to buck trends. The law is very slow moving because it likes to be predictable. And so the courts have struggled with this issue, and various courts have answered this various ways. And there have been different district courts and different circuit courts that have answered this in different ways. And I don't know if this particular circuit court has answered this question. This would be Second Circuit Court of Appeals because it's New York, right? So I don't know if there's binding precedent in this circuit on this issue. But it's a reasonable point, right? Can I do this now or can I do this now? So the judge asking themselves that question during the conference makes total sense because they haven't looked at the law yet, presumably, right? They don't know the answer to the question. They're legitimately asking, I don't know if I can do this or not, which is always a good thing if you're the judge. It's like, can I do this? I don't know. I need to go check. So yeah, it's like you can't expect the judge to know everything about every law. So it's like, okay, I'm not sure if I could do this now or not. I know this seems a little bit iffy, but I'm vaguely aware that there's some law that might support this. So can I do this now or can I do this later? That's the only question I'm trying to figure out right now. Makes total sense. Yeah. And if that's the question you're asking, you might want to reassess. Yeah. A defendant respectfully seeks attorney's fees and costs permitted under the Act. Good times. Section 505 of the Copyright Act. And as I pointed out, we work under the American rule or the English rule. Every side has to pay their own costs, including attorney's fees. You can't sue the other side for attorney's fees. Unless, of course, there's an exception. And this would be, it would qualify as an exception. And any civil action under this title, the court in its discretion may, discretionary. So, we just said discretionary twice, right? So we just said the exact same word twice. Discretionary may. That's the exact same word twice. But okay. In its discretion may allow the recovery of full costs by or against any other party other than the United States. So you can't do this against the United States, sovereign immunity, all that. Also, they're a lot less likely to run into this problem, so there's that too. Or an officer thereof. The court may award a reasonable attorney fee to prevailing party as part of costs. Great. So you can get costs, and you can also get attorney's fees. So that's also a point worth of bringing into a light. And there's been Supreme Court cases on this. in the patent law, I'm pretty sure, where the government actually lost on this exact issue. Because the statute in question allowed for awarding of costs, and the U.S. government tried to say, well, we want attorney's fees. And the law traditionally has treated those things as separate things because of the American rule or English rule. So where it said, oh, we can get costs, the U.S. government in that case said, well, we want attorney's fees too. And I think it was the U.S. Supreme Court said, no. No, attorney's fees are not costs. They are separate things. I understand they cost you money, but as far as the law is concerned, they're different for exactly this reason. And we use the terms differently. So you want to use them to be clear. So this statute's pretty clear, right? It says you can award costs and also you can award attorney fees. So that's not as repetitive as you might initially expect because the law has treated those as separate concepts because of those rules. Fair enough. When exercising discretion to award fees, courts give substantial weight to objective reasonableness of the losing party's position. Yes. While taking into account all relevant circumstances. Right? That makes sense. This is an issue of discretion. It's an issue of equity, essentially. So it's more equity than law. But, it's a balancing test, like equitable decisions usually are. And so it's like one of the things we're going to take into consideration is how reasonable were you being in your thing. We're trying to balance things, right? On the one hand, we want people to bring legitimate claims. And just because you lose doesn't mean your claim wasn't legitimate, right? These are different concepts, right? There's a whole bunch of reasons you might lose that would still make your position reasonable, right? Reasonable and winnable are not the same thing. So we don't want people to be deterred unnecessarily, but we also don't want people to be overly empowered by bringing cases they shouldn't. So that's what we're going to look at. How reasonable was your position? Fair enough. Objective reasonableness is not dispositive. Right. To be dispositive would mean it would dispose of the issue. It would be enough. You would be done, right? But you're not done. It's not you find this, you're done. No, it's not dispositive. It doesn't dispose of it. It is necessary, but not sufficient. District courts have discretion to make an award even if the losing party advances a reasonable claim or a defense, if the award will encourage types of lawsuits that promote the Copyright Act. So even if you're reasonable, we can still find that the award should be given if we're trying to promote the overall philosophy of the case. So even if you're objectively reasonable, we can still go the other way. So it's not dispositive either way. Just because you weren't objective doesn't mean we're going to rule against you. And just because you were objective doesn't mean we're going to rule in favor of you. It is a factor to be considered. The Supreme Court tells us fee awards should be encourage the parties with strong legal positions to stand on their rights and deter those with weak ones from proceeding, which basically is exactly what I said a minute ago, but in much more elegant and short language because it's the Supreme Court. So of course it is. And the fees should motivate defendants to litigate meritorious defenses to the same extent that they do to litigate meritorious claims. Fair enough. Isaac Wicks asks, I presume attorneys' fees are separate given that attorneys can charge people whatever they like to protect people from absurd costs. No, it's not because of that. It's just because of the historical rule. It's just because of the historical rule, the English rule. The rule is that people pay for their own costs, including their own attorney's costs. And so everything is in modification to a baseline rule. The baseline rule in this situation is everyone pays for their own side, for everything. Right? That's the baseline rule. And so we can and have made exceptions to that. Now, in awarding of attorney's fees, and I'm sure that at some point either side is going to get into this, but the attorney's fees themselves have to be reasonable in terms of the other side paying for them. Now, and in terms of your own side paying for them too, but to a lesser extent. So an attorney always has to charge a reasonable fee. Now, that view of reasonable is based on expertise and based on a whole bunch of things. So it could be quite expensive, reasonable, but an attorney can't charge an unreasonable fee. So if they charge their own side an unreasonable fee, the client can sue and get that money back. And for the same reason, if it's an excess fee, the other side won't have to pay all of it. They'll have to pay something of it. And I've seen that actually happen. I saw that happen one time. I want to say it was against, I forget who, but there was an issue where it was a really, really notable Supreme Court advocate. I don't think it was in the Supreme Court, though. But it was like a really notable Supreme Court advocate, like former Solicitor General or something. And he was in a district court case, because not every case can be Supreme Court. And he was asking for attorney's fees. And I think he was asking for the equivalent of like $750 or $1,000 an hour for him. And the court actually said, no, that's too much. Like a reasonable attorney's fee would be $450. And I actually felt like the court blew that one. For a normal attorney, even a really, really good normal attorney, $450 might be the cap. But as I said, this was one of the most notable Supreme Court advocates. I forget who it was, but I remember reading this. I remember thinking to myself, this guy's probably worth $1,000 an hour. This guy is probably worth it. I think the court might have missed the boat on that one, on this particular case. But yeah, it has to be reasonable. We'll get into that later. Good morning, Spermy the Cats. The Copyright Act serves the purpose of enriching the general public through access to creative works. To this end, copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed. Right. Copyright, it protects expression, not ideas. Idea-expression dichotomy, we might even call it. The copyright statute itself enshrines criticism and comment as non-infringing fair use. It sure does. I do not know about Vatican and City of London, though. No, I haven't heard anything about this one. This sounds promising. Just based on the title alone, unless you're talking about as legal constructs. Like, I know about the City of London as a legal construct separate from what is normally considered London. And I know about the legal construct of Vatican City. So if you mean that, then yes, I'm aware of the legal constructs of those places. I'm aware that the City of London is distinct from Greater London. Yes, I'm aware of the legal constructs and history of how Vatican City came to be. But if you're telling me that the City of London and Vatican are in some sort of legal tiff with each other or something like that, that would be epic. I'd love to read that. That'd be great. The Copyright Act's fee-shifting provisions ensures public access to transformative work by encouraging defendants who seek to advance meritorious copyright defenses to litigate. Thus, as in this case, the successful defense of misguided and censorious infringement claims furthers the policies of the Copyright Act. Yeah. What's the difference between a fee and a cost? Well, difference between a fee and a cost is fees are charged by the government and costs are charged by your attorney. At least typically how you use that language when we're talking about it in this particular concept. So if we're talking about fees, we're talking about things like the money that would be due to the person who's transcribing the transcript, or it would be due to the court itself, or it would be due to, is the money in some way going to a government entity of some kind? Then it's a fee. Is the money going to your attorney? It's a cost. There's your short rule. How about that? That's pretty good. Plaintiff's claims were objectively unreasonable because they lacked legal or factual merit. Yeah. As the court determined, it was clear from the face of the complaint that defendant copied portions of "We Thought She Should Win" for the transformative purposes of criticism and commentary. Yeah, she did kind of shoot herself in the foot a little bit on that one in her pleading. I'm not 100% sure she could have avoided the issue, but yeah, she did kind of shoot herself a little bit in the foot. I'm not sure leaving it out would have helped very much in the end, but yeah. Plaintiff knew and admitted in her complaint that Sargon's work was criticism because it was demeaning and belittling to her opponents, like plaintiff, of perceived liberal policies and stances. Yeah, again, I don't know 100% the degree to which this could have been avoided, but yeah, the lawyer might have considered that as they were considering whether to file this at all, but yeah. Yeah, le- le- well, the Sealand is not a recognized country. I'm well aware of the history of Sealand and its place on the oil platform off the coast and the whole history involving Sealand. But yeah, I, I, let's just put it this way: nothing that Sealand says or does is going to have any impact on anything whatsoever. Neither Vatican City nor London is going to do anything. Although, even if it's not, what will be the point of seeking in Sealand? Because the alternative is that it's British territory, right? At which point you would just sue it in a normal court of the UK. So what would be the point of bringing in Sealand? None of this makes any sense to me. I might be interested in that story though. If someone can like figure out how to give me that story, I might look in it. Could be fun. Even in the procedural posture, pre-answer dismissal on fair use grounds speaks to plaintiff's unreasonableness. District courts are ordinarily reluctant to make fair use determinations because of the fact-driven nature of the inquiry. Yep. Only in exceptional cases such as this one are all the facts necessary to establish the defense of fair use evidence on the face of the complaint. Yeah, that's fair. Such cases are exceptional precisely because they're unreasonable. I don't know that that quite follows, but sure, whatever. Even if plaintiff sued while harboring a subjective misunderstanding about the weakness of her claim, she quickly knew or should have known her complaint was unreasonable. This is Sargon's strongest point, right? This is Sargon's strongest point. Yeah. Did she know or should she have known at the start that it was clearly fair use? I'll give her a pass. But when the judge is basically warning her openly, and I don't know under the circumstances under which her first counsel withdrew. There could be a very lot of reasons, not of all of which are negative. He could have had other conflicts. He could have, wound up being busy. He could have been involved in other cases that got overextended. He thought something was going to be disposed of. He'd have time, and he didn't have time. So there could be a lot of logistical reasons for the attorney to drop out. There could be just a lot of practical reasons. Or it could be that he realized there was no case. If he told her, you have no case, even though it's confidential communication, of course, but that would have told her there's a problem. So when the attorney drops out, it does raise what's called a yellow flag of interest. It's like, something may be amiss here. Well, Isaac, jokes are hard to read on the black and white page. So you say something to me, I'm like, oh, okay. Well, I'm actually going to analyze this under its legal merits. That's how far I'm willing to go for you guys on the channel. That's how far I'm willing to go. You say Vatican City is suing London in Sealand, and I'm like, let me actually analyze the legal implications of that for a minute. I'm vaguely aware of these things. This doesn't really make sense, but sure, let's go with that. Oh man, you got me. What can you say? Where was I? Roughly as soon as defendant received a copy, his counsel informed plaintiff the claims are meritless. This is a Mulaney declaration. I don't know what this is or what declaration this is, but if you have a declaration from counsel that says this doesn't really make 100% sense. I'm confused by this because this would be attorney-client privilege, right? If I'm your attorney and I tell you your claims are meritless, like on what circumstance is that in a declaration of any kind? This is confusing me. This is weirding me out a little bit. Why is counsel and who is his? Roughly as soon as defendant. Oh, okay. Sargon's referring to himself. Okay. I got lost a little bit there for a second. I'm sorry. Strike that, reverse that. I got a little bit lost. roughly as soon as defendant received a copy of his counsel, referring to Sargon's counsel, informed plaintiff. Okay, now it makes sense why it's in a declaration. Now I'm on board, right? Because it's Sargon's lawyer, so Sargon can waive the privilege. So sure, that's fine. I don't know how dispositive that is, but or anything. If it was their own lawyer, it'd be a lot more interesting. But the opposing counsel say you have no case. It's like, how much weight should you give that? Probably not very much. Okay. The same letter put plaintiff on notice that if she elected, defendant would seek attorney's fees. Again, not exactly atypical for an attorney to say this. If defendant's stern warning were not enough, the courts ought to have been. Yeah, I mean, you can reasonably ignore opposing counsel's warnings because, it's every case, all of them. So, sure, the opposing side is going to give you bluster. You can ignore that. When the court's doing it, you should probably take a little bit more notice, though. Counsel for the parties appeared before Judge Sullivan in 2018 for a conference on defendant's anticipated motion. The court minced no words. The court. That would seem to me to be a kind of quintessential fair use, right? It informed plaintiff that her complaint described the ties as social commentary that is loud and celebrated. Indeed, according to the court, the only question raised by plaintiff's claim was whether fairness can be decided on a motion to dismiss or whether it'd have to wait, because of what we said before. Right? As everyone who might be following me as a result of the ongoing Vic Mignogna drama, they will be aware that in motions to dismiss, we normally only consider the plaintiff's pleadings. We normally only look to the prima facie case of the plaintiff's argument, right? This has been traditionally what we do. So normally we just ask, did the plaintiff provide enough evidence on their pleadings to provide a prima facie case? If so, we're done. We don't normally worry about anything the defendant has to say, because that's not what we're doing here. We just normally say is what the defense says what does the plaintiff say makes sense. We'll take everything as true unless it's so bizarre that we'll no, that can't be true. But if it's in some semblance of something that resembles a potential reality that would be logically coherent, then we'll normally just say, okay, everything you say, plaintiff, is true. Do you still win? That's a motion to dismiss, right? We all remember this from our Vic Mignogna coverage, right? So, here we are now. We're suddenly considering things the defendant has to say, right? We're now weighing defendant's evidence, right? We're weighing defendant's evidence as part of a motion to dismiss, right? So in both the Vic Mignogna case and the Sargon of Akkad case, when we're doing that, it raises flags, both to the court and to people at large, because this is not normally what we do in law, or it's not traditionally what we have done. And I don't know the degree to which, off the top of my head, because I don't know it that well, I'm much more familiar with federal law, but I don't know the degree to which the TCPA modifies these rules, right? I would assume, without more, the default rule in Texas generally is we look to the plaintiff's pleadings on their naked face, right? That would probably be the general rule because it's the general rule normally everywhere. But the TCPA may modify that, just like 17 U.S.C. 505 modified it for the Copyright Act in terms of the payment of fees, and the case laws modified it in terms of consideration of things and when you consider the defendant stuff in the motion to dismiss. So it might very well be in the case of the TCPA, and I'd have to go back and read it, it may very well be in the case of the TCPA that the rule has been modified and we should or must, to some degree, consider what the defendant has to say in weighing the prima facie case. So, for the same reasons the people following the Vic case would be questioning whether or not anything the defense has to say should be factored into the prima facie case, that's the exact same thing the federal court here is saying. Should I consider what the defendant is saying? In other words, I have an affirmative defense. Should I consider that as part of a motion to dismiss? It raises very similar procedural questions and very sort of weird things. And the federal law, as I pointed out, I don't think is unanimous on this issue, but there is case law standing for this proposition. I don't know if it's in the Second Circuit where this would be, but, there's case law standing for this proposition. And either the TCPA itself or the case law interpreting the TCPA may be of such a nature that we should or must consider the defendant's stuff as part of the motion to dismiss, even though we wouldn't normally do that. So that's, how this is working out. It's not something we normally do. The court's a little bit flaky about it, but, if it's the law, it's the law. So hopefully that was helpful as we try to analogize one case to another and try to explain how principles of one case might apply to principles of another case. So hopefully that was helpful. Good times. Yeah. 2020 Jameson said if they went after the first attorney, he could waive it to defend himself. If it was part of a lawsuit against him, yes, the privilege could be waived, but that hasn't come up here, and it wouldn't be here in this context. It wouldn't be admissible here, even if it was admissible somewhere else for the reasons you're saying. So, if there were a lawsuit against that attorney, then yes, he could break privilege for that purpose, but it still wouldn't be here, but noted. Why exactly would they factor in affirmative defense exactly? I'm confused. Yeah, okay. Well, no problem. We can spend a little bit more time on this because it is a little bit unclear. I apologize. It's clear to me, but I can understand how it'd be unclear. So let me try to see if I can explain. I'll just start over, and hopefully this will be helpful as I try to explain it. Because if I say the same thing multiple different ways, then hopefully it will be helpful as a teacher. All right. So normally, motion to dismiss, normal standard motion to dismiss rule. Normal standard motion to dismiss rule. Normal standard motion to dismiss rule is we take the plaintiff and everything they say in their complaints and anything else that's like attached to it, because motion to dismiss is based on the pleading. There may be some minor exceptions to this, but it's based on the pleading. And sometimes there can be attachments. So basically, in a standard motion to dismiss, what you do is you read it and you say, okay, every word of this is true. Every word of it is true in terms of the facts, right? Every word of it is true in the facts. All right? Then you say, okay, if every word of this is true in the facts, can they win? And if the answer is no, then you dismiss. And that reminds me of one of my favorite cases we did on this with Leonard when we did the Happy Time Murders case where Sesame Street was suing Happy Time Murders. And I read it and I was like, no. And it wound up being dismissed later that same week. So that was fast processing. The court punked it within a week because it was so stupid. And I was like laughing at it because it was ridiculous. I'm like, every word of this is true and it doesn't make any sense. So yeah, that's basically your standard motion to dismiss. You take every word that's in the pleading as true and say, well, do you have enough to make the legal argument? And, if the answer is yes, then we move on to more steps. Then we normally move on to discovery, then we do some stuff, and then we say, okay, based on the evidence, is there enough to go forward to a trial? So that's your standard rule. And then, so in trademark and copyright, which are the contexts where I know it's come up the most often, there's this affirmative, well, whether or not it's affirmative defense or not is a whole nother philosophical framework. But there is in the law fair use for both trademark and copyright. So if the essential bare line pleading of a copyright claim is because on the essential bare line pleading of a copyright claim, Akilah has essential bare line pleading. She does. It is a derivative of her work, right? One of the copyrights, because there are plural of them, one of the plural of the copyrights is the right to create derivative works and the right to create new works from that work. So did Sargon create a derivative work? Yeah, no problem. No problem that he created a derivative work, right? I mean, he used all of her content and nothing more. It was just her content and created something from that compilation. So it's derivative work. But one of the copyrights is the right to create a derivative work. So on its essential bare line pleading, Akilah has enough to go forward. So if we don't look at the affirmative issue, if we don't look at the defense's issue, then we move forward to the next step. But when it comes to the fair use thing, the courts have, over the years, been saying, well, wait a second. This doesn't make sense necessarily because we may be able to decide everything based on what we have, right? Especially like in the case of a copyright issue. Because it's often the only two pieces of, there's only really two pieces of evidence that matter. There's only two pieces of evidence that matter. There's the original and there's the infringing, right? There's only two pieces of evidence, right? And everything else is fluff. So we only have really two pieces of evidence. So why do we need to go to discovery and all that when we already have the only two pieces of evidence that matter? But because it's an affirmative defense, it's something the defense has to bring up. It hasn't traditionally been brought up. But the courts have said, wait a second, this seems a little bit odd because we're going to go through all the expense of discovery, which can be quite expensive and quite burdensome, in order to find things that are going to make no difference, right? We already have the essential things we need. So, like, can't we look at that and save ourselves a huge amount of time? Why go to discovery? We already know everything we need to know. I mean, if I look at just what the plaintiff says, we should move on. But that seems dumb. Why would we do that? Why would we do that when we already know everything there's to know? We're not that stupid. So, the courts have been playing with this because it's, on the one hand, it seems blatantly obvious. But as I said earlier, the courts are very, very lower C conservative. Very lower C conservative. Very. The courts like to do things that are based on what has been happened before. The courts are very slow moving. They like predictability. They like what is known. They like precedent. And they are very hesitant to change the law because they are very worried about the ripple-on effects of those changes. Because once you lay down this new precedent, it's going to be cited for till the end of the world, and who knows what's going to happen. So courts are very skittish about this for very good reasons. But as the courts have been playing around with it over the last, 10 years or so, that's about right, 10 or 15 years, about that wrong. As they've been playing around with it, they're like, no, we're gonna start bringing this stuff in and save ourselves a whole bunch of time. And because we only have two pieces of evidence that matter, and it's exactly true here. All that matters is the original videos from Akilah and what Sargon did. Like, there's nothing else. There's no other evidence that matters, particularly because copyright is strict liability. What other evidence is there? Why do we need to depose anyone and ask them any questions? What does it matter? We have all the evidence that matters. There's nothing more, right? So why not save ourselves the effort? But because it's a change of the baseline understanding of what motions to dismiss always have been, the courts have been very skittish about it. But as the courts have considered it, as I've pointed out, they have brought this in gradually. It is not universally true. I don't even know if it's true in this circuit. I presume it is because the judge is doing it. But, they've been doing it for exactly that reason. So, by analogy, Texas may do its own thing in its own law. Right? When we're talking about Texas state law, Texas is master of its own law. The Texas courts are master of interpretation of its own law. The Texas legislature is the master of writing its own law. So, the general philosophy of the TCPA, is on the baseline pleading of, here's a whole bunch of things this person said. If we just look at the baseline pleading, often we would go forward to the next step of discovery. But when we're talking about free speech and we're talking about people exercising free speech when it relates to opinion and fees, right? When we're talking about people's fees being hurt, we're concerned about that because discovery is so expensive. We're concerned about that. So what we want to do is, if what we want to do philosophically is we want to say, well, if we just look at the baseline pleading, we're going to go forward and go to discovery. But maybe we can save everyone's time, and maybe we can protect people's free speech on the same token. So either the TCPA itself in the statute of it, or in the case law interpreting the TCPA, or potentially some other case law interpretation, because of course it's not the only law in the books, the courts or the legislature have potentially modified it along the same lines. They've said, look, we want freedom of speech as a paramount value, so we are going to break from the normal default rule of only looking at what the plaintiff does as part of the prima facie case. Because normally in the prima facie case, all we do is look at what the plaintiff does. But what we're going to do is we're going to say, to some degree, we're going to look at what the defendant has to say as we're considering the prima facie case. And the philosophical rationale is parallel to the reasons that you're doing it in these trademark copyright cases, to save time, to protect people's legal legitimate interests, and to prevent, the reason that this is being used is exactly to prevent copyright law from being used as a muzzle to freedom of speech, right? That's what we're concerned about. We're concerned about people using copyright law as a muzzle to freedom of speech. So we are going to consider this as part of a motion to dismiss to solve that problem, right? And in defamation law, same issue. We don't want people using defamation law in general to silence legitimate freedom of speech. We don't want it being used as a club outside the purposes for which it was invented. So we don't want people like Akilah using copyright law to silence legitimate speech of Sargon, right? We're all on board with this premise, right? And in the same way, potentially, we don't want people like Vic to use defamation law to silence the legitimate free speech interests of Funimation, Monica, so forth and so on, right? It's the same construct. It's the same philosophical construct. So I would respectfully submit to all the people who like the outcome in this case, just apply the principles of this case philosophically to the Vic case, and you'll be understanding like why the law is going the way it is. So that was actually a really good discussion because it goes to explain some things in a way that makes sense. And I do take some note that there does seem to be a bit of a disconnect between some of the Vic people who seem to think that the TCPA is of the devil, but they like the outcome of this case. I'm like, I'm not sure you can have it both ways, guys. I'm not sure you can have it both ways. I'm not sure you can like the outcome of this case and think the TCPA is of the devil. So, yeah. Plaintiff claims were objectively unreasonable. That alone is substantial weight tilting the scales. Yes. Yeah. Yeah. Tilting further, a fee award is warranted because plaintiff makes no reasonable effort to settle or dismiss her meritless claims. The losing party's lack of reasonable attempt to resolve is relevant to the need to advance considerations. Yeah. Plaintiff's contents begged for an award, nice choice, because defendant had no choice but to litigate. Yeah. Plaintiff made no settlement offer at all until the March 2018 initial conference. Despite having been warned by the court, their claims lacked merit. Plaintiff demanded $46,000, which I can only presume were roughly her costs at the time, or close to it, right? Because where else is she coming up with that number, $46,000? And it seems reasonable. Because Sargon is asking for, what was it, 30 something, $37,000, and she's asking for 46, and she had already been through one attorney before this, so 46 was probably her break-even point. So that's probably about how much she spent on attorney's fees. That makes sense. So she still has to pay. She still has to pay that $46,000, and she's going to have to pay the $37,000 to Sargon. So she's out $100,000 for her bogus cause of action. Ask me how sad I feel about that. Not very. The unreasonable demand exceeded not only any conceivable recovery, but the costs the defendant had the claim dismissed. Yes. What is the TCPA? Oh my Lord. You're asking me this question, and the only reason I'm hesitant is because last time I made a mistake on the acronym, and the Vic people got really, really mad at me for making a mistake. What is it? Is it the Texas Citizen Participation Act? I believe it is. It's the Anti-SLAPP Act in Texas. It's the Anti-Strategic Lawsuit Against Public Participation Lawsuit in Texas. And it stands for Texas Citizen Participation Act. And on the last stream, I said Texas Citizen Protection Act many, many times. And the Vic supporters were up in my grill about this. Like, well, he can't even get the acronym right. He can't even get the acronym right. Oh, yes. Let me tell you guys. Let me tell you. My opinion on the Vic Mignogna case is totally going to turn on the fact that I made a mistake on what TCPA stood for. I said Texas Citizen Protection Act. It really is the Texas Citizens Participation Act. Wow. My opinion has changed because of that one mistake. That was definitely something to go to the wall for, guys. Yeesh. He intentionally advanced only strongest defense, so they'd be determined on the merits. Defendant also conducted himself reasonably well by retaining experienced small firm counsel to represent him at discount rates. Yeah, his fees are reasonable. A party is motivated when its assets claim not because of their inherent merit, but rather because the party seeks to knowingly gamble. By the way, this is a little bit off point. I'm sorry, my voice is cracking. It's a little off point, but several people in the comment threads relating to the Vic Mignogna coverage suggested I should reach out to Rakita. And so I did. I sent Rakita an email. I sent him an email like 2 or 3 days ago. And on his live stream last night, I was there, and so I was participating in the chat, and Rakita said, you know, I've noticed you, and I'll get back to you. When I gave him super chat for $5, said, no problem, take your time, right? Because I don't think I'm entitled to Rakita's time at all. You know, he has his own thing to do. I don't think I'm entitled to a response. You know, the only thing I think I'm really entitled to is being nice to. So as long as he said, no, I don't have time, or, you know, even if he ignored me, that'd be fine. I appreciate he not being a jerk to me, you know, and laughing in my face. That's the only thing I'm entitled to is, I think, a little civility. But, you know, I don't think I'm entitled to his time. And so if I didn't get a response at all, I wouldn't have been mad, you know, and I don't think I'm entitled to his time. So, you know, if we wind up talking about this or something else, that'd be cool. If we wind up talking about the Vic Mignogna case, that should be really interesting in the chat, I'm sure. That will be entertaining. So we look forward to that potential thing. Good times. And as I've said many times, I have nothing against Nick Rakita. I think he's a reasonable guy. I think he's a smart guy. I think he's a little biased. He thinks he's a little biased. But I listened to his stream last night, and I thought he was, you know, I was like, okay, all of what you're saying makes sense. I just don't really agree with like the end conclusion. But the analysis makes sense, right? So I'm not like saying, oh, you made some massive mistake. It's just we're trying to like analyze this and coming out slightly differently. So we'll see if that happens. That should be fun. A party is improperly motivated when asserts claims not based on the inherent merit, but rather because the party seeks to knowingly gamble on an unknown legal theory in order to achieve a secondary gain. Since plaintiffs have no inherent merit, the only rational motivations are improper ones. The plaintiff here knowingly sought at least 3 improper secondary gains. Intent to silence criticism, sought through the improper use of copyright to silence critical speech. She falsely claimed to YouTube that Sargon's critical video of her infringed copyright. As a result, YouTube disabled public access to the video. This is plainly contrary to the copyright's goal of ensuring access to critical works. Thank you, Deep Cover, for that very backhanded compliment. I appreciate it. Thanks. After filing the lawsuit, the plaintiff pressed on, not that you're wrong. I'm not saying you're wrong, but you know, okay. After filing the lawsuit, plaintiff pressed on with a censorious attack. She tweeted to her 100,000 followers that this carnival barker, and I do like that language, nice choice, that I'm suing for copyright infringement just got banned from Patreon. Do you think we can get GoFundMe to drop him? The request unmistakably incites plaintiff's fan base to swarm defendants off the fundraising platforms where he appealed for donations to defray the costs. He lists the funds are for defense of the lawsuit. Yep. Part of the same tactics, plaintiff later publicly suggested on Twitter she reported defendant for hate content to Patreon in an attempt to have Sargon banned. And in keeping with her strategy to repurpose copyright law as viewpoint-based censorship, that's a no-no. She reblogged with apparent approval suggestion to drown out fascists by not criticizing their viewpoint, but rather by bringing a speaker to play copyrighted music at the rallies, because it'll be easier to report their video and get them taken down. Yeah. Plaintiff has used this lawsuit as part of a campaign to silence criticism. She then openly attempted to bar defendant from raising funds necessary to her legal defense. Her motivation stands opposite to copyright's goal of ensuring public access and that merits fees. 2012, Jameson says, I do find a distinction between two cases. What happens when affirmative defense conflicts with Vic's evidence? That leads to a fact issue. It could. Yeah, it certainly could. A difference in fact issue, because there's no difference really in facts between Akilah and Sargon, right? It's a straight legal difference. They don't really disagree on the underlying facts. So that is a potential point to distinguish the cases, wherein in the Vic case there is a dispute over the facts, and so at least that's a fair point. And then you would have to potentially get into what the TCPA or the case law allows for in terms of how to weigh factual disputes as part of a prima facie case, right? So again, you can modify this normal rule. The normal rule is we look at just what the plaintiff says. We assume everything the plaintiff says is to be true. That's the normal rule. But that rule could be modified by Texas. So I suppose the next logical question is, has it been modified by Texas? Has Texas, as part of the TCPA and or the case law interpreting the TCPA, has Texas said that you should consider factual disputes, bring in factual dispute evidence by the defendant, and consider that as part of the prima facie case? Which again, is not something normally you would do. But could Texas do it? Yes. I suppose there's no reason not to, right? It's just, all these things are just normal rules of normal things of procedure. These are procedural rules, right? So, to what extent, if any, could you bring it in? Presumably, there's no limit. Presumably, Texas could do as it likes. So, I don't know the degree to which the TCPA allows for, or the case law allows for, consideration of factual disputes and consideration of evidence of differences of facts from the defendant as part of the plaintiff's prima facie case. Even saying those words out loud, that sentence doesn't really make sense, right? Even saying it out loud, it's that doesn't really make sense. But could it be? Sure. It would be weird as hell because that's not normally how you think of prima facie. This would be a very strange definition of prima facie, but yeah, there's definitely distinguishable. And then you have to get into, did Texas distinguish it that way? Are they distinguishable in theory? Sure. Did Texas distinguish it that way? Who knows? I'm not that expert on Texas law. Maybe later. Yeah. Plaintiff deliberately played this case for publicity. Before filing, she teased to her fan based on Twitter that she had a Christmas present on the way for Sargon. Shortly after filing the complaint, she promoted to her YouTube audience in a video, which she proclaimed, I'm suing a grown man who goes by the name of Sargon. Okay. You go by the name Akilah, obviously. And you're a grown woman, so, glass houses and stones and all, geez. In the same video, plaintiff taunted the defendant and whipped up her own fan base by intimating that Sargon is a poor father because he dared to criticize plaintiff. There's plenty more of the same. Plaintiff tweeted of Sargon, I'm currently suing his white supremacists for stealing my content. Yeah. I always try to be honest. Otherwise, I'd be a very poor teacher. Oh, was prima facie. Prima facie. I will type it out for you. PRIMA FACIA. Prima facie. It means on its face. Because it's Latin, because it's the law. But it's prima facie. It means on its face. So when you're talking about a prima facie case, you just mean on its face it would work. That's what prima facie is. But yeah, it's Latin because it's law, so of course it is. There's plenty more of the same. Plaintiff tweeted of Sargon, I'm currently suing. Plaintiff tweeted, I'm going to take hundreds of thousands of dollars as demonstrated from her own conduct. Plaintiff used the lawsuit to broaden and appease her own fan base to bait antagonists and otherwise generate valuable attention and celebrity. Perhaps not surprisingly, all this occurred while plaintiff planned and promoted a new book. Plaintiff's public statements about the case prove she's motivated not by purposes of the Copyright Act, but by a desire to extract a cash settlement from defendant. For example, plaintiff publicly promised, without basis of facts, hundreds of thousands of dollars from Sargon, and referring to the case, she told followers to let's bankrupt him. As discussed above, moreover, plaintiff improperly sought to leverage interim value of her case, more Latin, in a bully settlement. Do new legal terms get translated into Latin? Well, that would presume that there are new legal terms, which I'm not sure there is. Because we've been doing law for a long time. But no, probably not. If anything, the trend is to try to get out of this and get back into plain English. So, yeah. Her only settlement demand of $46,000 strains the boundaries of good faith. Even if plaintiff had established infringement, she would be entitled only to minimal damages. As the court found here, there's no danger that SJ levels of awareness will usurp the progressive commentaries such as we thought she would win, because Benjamin's target is obviously, nice word choice, by the court, the same as Hughes' target audience. I'm sure it was an unconscious word choice by the court, but I will praise it nonetheless. Moreover, setting aside other factors to make her claim patently meritless, there was no basis to demand statutory damages since she did not register the copyright until after defendant had engaged in transformative conduct. Can I look into Doschet versus Sons of Confederacy? Potentially. I'm going to put it on my potential list of stories. But thank you for the super chat. Any improper motives would independently support an award of attorney's fees. Defendant respectfully submits that together they compel one. Defendant's request amount to $33,000, which is pretty cheap. She's getting off light. His actual attorney's fees plus $5,000 for these. So $38,000. These fees are as follows. Okay. He did pretty well. Courts use the lodestar method to calculate attorney's fees under the Copyright Act, which is accounting terminology. The actual billing arrangement is a significant factor in whether it's reasonable. This gets to what I was saying much earlier in the stream when they're looking at the award, that it has to be reasonable fees, and that's what they're talking about now. Rate is reasonable that a client would be willing to pay. Defendant seeks only the amount paid. The amount is reasonable. The amount is reasonable. It's a pretty good break. Might get angry at YouTube at saying that particular name. What particular name? Did I say a name I wasn't supposed to say? The costs also include $126 in court reporter fees. Difference between fee and cost, right? We discussed that. It's cost because it's going to a government entity of some variety. For the purposes of this exercise, the transcriptionist counts, even if they're a private entity, which they usually are. But they're working in the court. So for the purposes of this, they're government entity. Yeah. Stay above. We want this money. Great. No problem. Great. Let's move on to her response. Oh, Confederacy? Sure. Okay. Well, either way. So let's look to Akilah's response. Let's look to see what she has to say. This should be good. I thought Sargon's argument was pretty persuasive. I noticed it's a lot shorter. Plaintiff is a popular internet personality and content creator who publishes video on her YouTube channel, Akilah, obviously. Again, I have to say, when you were saying, Akilah, that he's a grown man, he uses the term Sargon, glass houses and stones, Akilah, obviously, glass houses and stones. Also, as a person who calls himself Blackleaf on the internet, I'm not going to criticize anyone for these names. So, yeah. On the night of 2016 presidential election, Plaintiff captured footage from Hillary Clinton's presidential watch party, used the footage to create an original video and used the footage to create an original video essay which incorporates nipple footage along with monologue. The resulting video was 9-minute and 50-second work entitled "We Thought She Would Win." Defendant is a popular internet personality, so I guess I take some note that Akilah is admitting that Sargon is popular. So, okay. Who publishes video content on his YouTube channel, Sargon of Akkad. Defendant created 1-minute, 28-second video containing clips. Prior to commencing the lawsuit, plaintiff submitted a notice requesting removal. Thereafter, plaintiff and defendant engaged in a number of email exchanges debating whether the creation was fair use. In response, YouTube disabled the work. Defendant submitted counter notification. Yes, we're all in good. Well, be that as it may, Isaac. It's what's happening now, so deal. Under the guidance of the plaintiff's former counsel, plaintiff commenced the present lawsuit. Subsequent to the initial conference, where plaintiff was represented by new counsel, plaintiff submitted an initial settlement offer to defendant. No counter offer or attempts were made to resolve the matter. Instead, defendant filed a motion to dismiss. Defendant moved for award of attorney's costs. Plaintiff now submits its opposition. I suppose the counteroffer would be dismiss your case, but yeah. The standard, Section 505, gives discretion to award fees and costs. They should not be awarded as a matter of course, but makes a particularized case. In making it, a number of non-exclusive factors should be considered. Objective reasonableness is afforded substantial weight. The ultimate inquiry is whether it furthers the large objectives. Right? This is the exact same statement of law we saw from Sargon, right? The exact same statement of law. So we agree that this is the law. We agree that this is what we're supposed to be doing. Fine. Let's say, now that we agree on the law and we agree on the facts, right? So she gave a fair statement of the facts, right? She gave a fair statement of the law. So let's see why, given a common understanding of the facts and a common understanding of the law, why the analysis goes the other way. Which, incidentally, again, is potentially the issue as it relates to me and the Vic Mignogna case. Right? It might be the case that I'm factually mistaken. It might be the case I'm legally mistaken. But neither of these things is necessarily true, right? Because these people agree on the facts and law. So it might be the case that I'm factually well-informed, I'm legally well-informed, and yet I come out differently on the analysis. So there's that. With an award of attorney's fees and costs, add to the rewards of victory. I was also like noting in the comment thread to my own videos, and I noticed it on Nick Rakita's stream last night, that a bunch of people were saying how like off the reservation. Well, let me paraphrase. They were saying that I was completely like factually wrong, and it was really infuriating to watch my analysis because I was so factually mistaken. I'm like, I suppose that's possible, but I read a fair amount of this, so I'm not sure how massively mistaken I could be. But you know, I'm looking forward to being schooled on the massive mistakes I've made of fact. Like, I don't know, man. You know, I will concede that I again, when I said I'm not sure that depositions are part of the record, I was using the word in a loose sense. It wasn't exactly that I made a mistake, but I was using it in a very loose sense where I shouldn't have used it that loosely because the Vic people love the precision. So what I should have said is the declarations aren't part of the record because you're like, the depositions are part of the record. What are you talking about? You know, that was a linguistic choice on my part that was in retrospect error. So I should have called them declarations instead. But yeah. Okay. While the awards of attorney's fees adds to the reward, it also enhances the penalty for defeat. In cases where good faith claim has been brought and lost, an award of attorney's fees may repress the purpose of the Copyright Act. This is especially true in the application of doctrines that are not clear but require a case-by-case analysis. In these instances, it is difficult for a party to confidentially know whether they'll win or lose. That is true. Yeah. Hello, Tala. Hi. Hello to you. I commend you, sir, for being understand and unlike the people on Twitter who claim they know the law and choose to stand with Vic, but I want him to have his justice the right way. You know, I try. I'm trying to be honest. You know, I'm not part of the Kick Vic crew. I'm skeptical of Me Too claims. I'm skeptical of a lot of this stuff. If we want to talk about what actually happened to Vic in reality, we can have that discussion too. But like the legal discussion is, yeah. Yeah. Plaintiff commenced this action for copyright infringement with good faith belief, defendants copying and uploading of wholesale reproductions of original content, and adding that title was insufficient the amount of fair use. Plaintiff motivations were clear. She believed the secondary work was an infringement and that fair use did not apply. This was her sole motivation for commencing the action. That might be true at the point of commencing the action, Akilah. That might be true at the point of commencing the action. I don't dispute that, and I'm not even 100% sure Sargon necessarily would. At the point of commencing the action, sure. But some things happened after that point that raised serious questions in people's mind. It's also clear that the heat of the moment banter between Plaintiff and Defendant is irrelevant to her motivations for commencing. That doesn't work. The heat of the moment banter is irrelevant. The heat of the moment, in other words, it's contemporaneous because it's happening at the same time, right? That's what that would mean for it to be in the heat of the moment. Another way of saying that is contemporaneous. So you're saying your contemporaneous statements are irrelevant as we're considering your motivations for things you're doing at the exact same time as the statements you're making. No, I'm thinking. I'm thinking they might have some relevancy, Akilah. If you're making statements at the same time you're doing things, I think it's potentially reasonable to consider the one in light of the other. I think that's a reasonable thing to do. Plaintiff literary claims reasonably. No. Prior to filing this motion, plaintiff sought to settle this matter by providing defendant with an initial settlement offer while remaining open to settlement discussions. After you were told by the court you had no hope. Plaintiff made a reasonable attempt to resolve the litigation. No. Defendant chose not to counteroffer or attempt to engage in any discussion whatsoever and filed a motion to dismiss. Yeah, you should have probably just moved to dismiss yourself. That would have been good. Defendant hasn't been adequately compensated. Defendant raised money to fund a defense of this lawsuit via GoFundMe campaign. I need a wall to beat my head against real quick. Hold on. No. Absolutely not. No. That doesn't even begin to make sense on any level at all, of any description whatsoever. He's been adequately compensated. That's the stupidest. I keep wanting to use that phrase. It's the stupidest thing. And then every time I want to use it, I then consider all the other things. And I have to interrupt myself just because the amount of stupid. Let's just say it's a stupid thing. It's a stupid thing to say. Rather than it's the most stupid, whatever I was about to say. It's a stupid thing to say. That doesn't make sense. If he had used money in his bank account that was just sitting there to fund his lawsuit, it would have not been compensated. It was his money. So if he asked money from friends, like suppose he just went to like his okay, like let's say that Sargon has a rich relative, okay? And he said, "Hey, rich relative, can you give me the money for this lawsuit?" And the rich relative said, "Sure." He's been adequately compensated for the loss for the money? No, it was his money. The rich relative gave it to him, but it was his money. He still had to spend it. So he still spent his money. So all the people gave him the money, but then it was his money. So he still spent his money. It doesn't make sense if it came from one rich source. It doesn't make sense if it came from 1,000 people. It doesn't make sense if it came from a community. It doesn't make sense if it came from his bank account. This doesn't make sense on any level whatsoever. This is a stupid argument. I don't like this, and this hurts me. No. Defendant raised £95,000. This is approximately equal to $121,000. Why do I care? Why do I care? I don't care. I don't care on any level. I don't care if it's GoFundMe funded $5. I don't care if it was $5,000. I don't care if it was $50,000. I don't care if it was $500,000 or $5 million. I don't care about any of these things. It's completely irrelevant to the issue at hand. Who cares? No one cares. It doesn't matter. What are you talking about? None of this, no. Defendant incurred fees and costs of $38,000. After deducting his attorney's fees, he's earned a surplus of approximately $83,000. Defendant has already been adequately compensated. An award of attorney's fees and costs would be unjust. There's no precise rule or formula for making attorney's fees determinations, but instead, equitable discretion should be exercised, and courts must view all circumstances and case in light of the essential goals. Right. This I agree with. It's essentially equitable, right? That would be fine. Yes, I agree with this. An award of attorney's fees is justified in particular circumstances to advance considerations of compensation deterrence. This is not one of these circumstances. Defendant's consideration of deterrence may support an award of attorney's fees to a prevailing party where none of the other factors justified in such an award. As evidenced above, the other relevant factors do not support an award of attorney's fees. The plaintiff's motivations were in good faith that she litigated the case reasonably. Notwithstanding the above, defendant's success and his GoFundMe earnings have furthered the purpose of wow. Okay. I'm sorry. It was so stupid. My brain refused to keep reading. It was so stupid. It refused to keep reading. Hold on. I have to properly steel myself. I have to properly steel myself for this. I have to take a deep breath. Okay. Let's try this again. Notwithstanding the above, the defendant's success and his GoFundMe earnings have furthered the purpose of the Copyright Act and an award of attorney's fees and costs would not add to the existing deterrent effect. Plaintiff has faced widespread public criticism as a result of losing her lawsuit. Well, people have a right to comment and critique. As you have learned, one of the essential purposes of the Copyright Act, and more to the point, one of the essential purposes of the First Amendment, which I know you're British, right? No, you're American. Sorry. Sargon is British. You're American, so you should know better. One of the essential points of the First Amendment is criticism and critique. So you filed a stupid lawsuit, and people have been analyzing that you filed a stupid lawsuit, and you were warned about the stupidity, and you kept going, which is stupid. I mean, stupidity after being warned explicitly by a judge. It's notable. We might have some comments regarding this. So you entered the public arena, you got smacked down hard, and you have been mocked for it. Which, is basically exactly what you were trying to do, right? Let us all remember. Let us all remember in alternative world, where Akilah won this case, she was looking to bring Sargon into ridicule and financial distress and mockery and all the rest of it. Look at this guy Sargon. Look at what he did. Look at how horrible he is, and look how all the things he did. And go criticize him for his blatant copyright infringement in some alternate world where she wins this. So, she's on the other end of the paddle, as it were. She's on the other end of the paddle she started swinging. So now she's gotten spanked by it, and it hurts. How sad can I possibly be? Not that sad is the answer to that question. An award of attorney's fees will only be additional unjust punishment for good faith to enforce. Okay, well, that's the end of this lawsuit. All right. I figure there's a 95% chance the Sargon is going to get his fees. I think there's a 95% chance he's going to get his fees. Because the fees are relatively low, which really helps, actually. They're relatively low, so the court doesn't have to think about it as hard, right? There's reasonable and there's reasonable, right? If we assume for the moment that reasonable attorney's fees could have been, say, $70,000, which I don't think is beyond all reason. It's a lot, but if we could assume it's $70,000 and you're only asking for $38,000, it makes the job of the judge much easier to say yes, right? If you're only asking for $1, it makes it much easier to say yes, right? It's like, yeah, it's $1. Who cares, right? Exactly the same kind of logic you did, right? It's like, if you're walking on the street and a bum asks you for $1, you might give it to him because it's $1. If you ask for $10,000, not so much. You know, so that's some same sort of cognizant like bias affects judges too. If you're asking for $1, they're not going to think about it very hard. If you're asking for $100,000, they're going to think about it harder. So the fact you're asking for as little as you are makes it a lot more likely, because it's just cognitive biases that we all deal with, and judges are human, lest we forget. So there's that, and the fact that she was actively warned about the judge and kept going. You know, so there's that, and Sargon told her in advance and warned her in advance and communicated all this to advance to the council. She was in full knowledge of it. So, yeah, I would imagine that this is going to be resolved fairly soon. You know, I'm not seeing. I don't even know if Sargon files a response. He probably can, but why? He might file a response, but why? Nah, he might. But I figure, the judge is going to make a decision much sooner rather than later. There's not a whole lot to consider here. The evidence is pretty clear, so I wouldn't be super surprised to see a judge's decision. Let's see, what day is it? Thursday? Well, depending on whether or not Sargon responds, and he probably has to have the right to respond, and he has to do something. So if Sargon responds, next week, the judge will finish this out by the end of the month. So I figure the odds of an award of attorney's fees are by the end of the month, if not sooner than that. So, that's good times. Man. So that is the end of the stream. Thank you all for joining me. Thank you for the 65 of you who are watching me, and for the 28 of you who have liked me. If the rest of you would give me a like, it would be appreciated. Later today, I have a video coming out about qualified immunity being denied to a cop who walked up to a tethered dog and then shot it in the head for no reason. This is a thing that happened. So that video is posting later today. I think it's posting in about 2.5 hours. So that will be good. And you can watch a police officer get crushed by the Court of Appeals. The trial court thought it was totally cool. The trial court saw no problem with a cop walking over to the tethered dog and then shooting it in the head. The trial court thought this was totally fine. The appeal court disagreed. So thank God for that. And we'll be reviewing that. That's the case that's coming out later today. So, fun times. I'm going to sign off for now. Hope all is well. Look forward to talking to you later. Cheers and goodbye.